There we go. That's better. Good morning, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Wanted to get on, talk to everybody today about the UCC Reservation of Rights. And clarifying your capacity in regards to all of these commercial instruments and documents that you're signing. Brother of mine was on and they interrupted his video, hoping I can get him to come on here. Melvin, Washington, very bright young man, very quick-witted, and while he was trying to explain things about the UCC reservation of your rights, they interrupted his video. I wanted to get on and help explain it with him, but it happened right as they interrupted him, so I'm here to try to help explain that, and hopefully he'll come on and catch this. But when it comes to the UCC, I want to explain to everybody that's in regards to commercial instruments. And any time you sign anything, it is a commercial instrument, period. And my own experience, and you can look this up, I've mentioned this in several of my videos, you can look my name up, Keith Orland, not Orlando, Orland, O-R-L-A-N-D, and the first name spelling is K-E-I-T-H, and then of course the last name is Little, from Waterloo, Iowa. Now if you go to the public records and do a search on that name, you will find that there's all kinds of cases up there that are adjudicated, have been assessed fines and fees and penalties and all that. And I want you to look at the dates. And you'll see that there's 11 or 12 of them, I think. 12 would be including my last case, wherein they occurred anywhere from about 4 to 8 years ago. And my last case was the one that they actually dragged me into court. But I had 11 citations before that I signed, but I signed UCC 1-308 and then just never went to court. And then the last case, they drugged me in on a, because they pulled me over for invalid plates. Because I took the plates off of my car and my truck when I used them for private use and just put private property placards on them. When I was in actual commerce, I would put the plates on. Okay? And at that time I was working doing a rural route delivery, and so I had to have them on there for that rural route delivery. And actually even then I didn't have to. If you comprehend the commercial system these days, we have an unlimited right to contract, and we can do that between two people. We do not have to be involved in quasi-contracts with third-party interveners. And that's what the Social Security number is all about. What happens is the Social Security application is a contractual thing, and it exists throughout your lifetime. If you use that Social Security number on anything, like I said, it's a commercial instrument. So a lot of these people will ask for that Social Security number. Well, back to the case there, when they pulled me in, or pulled me over for invalid plates, they charged me with possession of marijuana, 6th offense, with subsequent charges. And if you think about the language, subsequent means that they charged me with the possession charge and then gave me subsequent charges after that. In other words, what they were saying is they pulled me over for possession of marijuana and then discovered that I had invalid plates. That's not right. That's a violation of maxims of law, first in time, first in line. So when they pulled me over for invalid plates, They technically were supposed to charge me for invalid plates with subsequent charges, naming the marijuana charge after the invalid plates, meaning that they're supposed to prove first that the plates were invalid and that they could then move forward from there and charge me with possession. And that's not the way it went. So consequently, throughout this whole trial on this, none of the other 11 citations were mentioned. None. Let alone, since that trial, since serving the 60 days on that trial, and I'll remind everybody here that all 5 previous offenses, I got what everybody likes to call a public pretender, and I ended up with a maximum on each offense every time. Full 2 years is what they give you in Iowa for possession, and each time they gave me the full 2 years with the fines, fees, and penalties, thinking, making me believe that I was getting off easy or something. Well, this time when I went in and I rejected the attorney, I told him that if he said one word for me, he would be held liable. And believe you me, people, they don't like that word. And that's what I'm going to get onto next, because when I told him I would hold him liable if he said anything, he didn't say a word the whole trial. And then when the trial was over, I did my time. They book you out. At that time, they call it a release. Now, comprehend that term there. That's a term. Lease is a contract. And then you put a prefix on it, RE, meaning they're going to do it again. Okay? That's that Social Security number. They released. Okay? They released my services. Okay? When they wanted to release me from the confines of the jail, the nice luxurious stay that I had for 47 days on a 60-day sentence, they let me out early. They told me I had to sign the release papers. I said, no thanks, not going to. Well, we can't release you. And I'm telling you, people, it only took me a matter of a couple minutes to explain to them that, well, tell you what, if you don't release me, that's a direct violation of court order that says you're supposed to discharge me. Discharge. Again, a term. Whereas I was charged, sentenced, did the time, and now I was supposed to be discharged. Now, if you want to go against that or violate that court order, that's fine by me, because I'll go ahead and sign any papers after that for the contractual terms on conditions of commercial lien. And so when we get back to this UCC thing, UCC 1-308 is what I used to sign on all those citations. And like I said, I just never went to court. You can look these up. They still exist. But there's no enforcement. There's no warrants. Nothing. And I'm going to explain this reservation of rights that Melvin Washington was talking about. In the UCC, there's one particular code that we all need to pay attention to, because everything's commercial. Like I said, when you sign your name, that's a financial instrument. And under UCC 3-402, subsection B, subpart 1, read that and you will see that it says, and I think I'm quoting it accurately here, the authorized representative giving an unambiguous authorized signature on the instrument is not liable for the person named in the instrument. That one code tells us that even these public officials, these public servants, these clerks, these magistrates, these clowns, these bar attorneys, no one's liable for their signature because they're signing on financial instruments as an authorized representative. Authorized representative of who? The Federal Reserve. The Federal Reserve is the one that institute the Federal Reserve notes, and it's the United States that has their code set up for all these other instruments based upon the Federal Reserve, the Federal Reserve notes. And I believe this is similar in every country, every nation, except for those that aren't part of that UN agreement. So think about this stuff, people. Read that code and realize and help wake yourself up. Get rid of that fear. Realize you are not liable for that signature if you just point it out. Excuse me. Whether there's a prosecutor over here running his yap, unlawfully or not, whether the person that's supposed to be making the claim is present or not, I care not about any of that. I care not whether you want to sit there and try to bully me or not on that bench, because I have the one code that says clearly, unambiguously, that I am not liable for that signature. The same as you, the same as this guy over here, and the same as the guy that signed that citation along with myself. Whether I reserve any rights or not, it clearly says. The one giving an authorized signature as the authorized representative, unambiguously, is not liable for the person named in the instrument, period. Let me try that again. That wasn't the exact quote there. The authorized representative giving an unambiguous authorized signature on the instrument is not liable for the person named in the instrument. Comprehend this, people. That's one of the things that when I realized that, I realized there's nothing in this world that can hold me to it. And I just quit signing. I haven't signed anything but one document since, and that was I went down to the courthouse and got an accounting of all those fines and fees and everything, and I tried to do an accept for value. Of course, I had already rescinded my signature from all the documents, so they're in agreement. There is no longer an accepted for value, and in fact, there is no longer an account. I've rescinded. And along with walking out of jail that day, we're refusing to sign and not signing anything since. That's been 4 years ago. And I believe the statute of limitations on their paperwork at Social Security is 2 years. I believe you can see that in the code for the Treasury Direct account, where they have the right to close an account after no activity of 2 years. And if you comprehend this, we have equal consideration and equal benefit. And so therefore, we have the right to close that account by inactivity as well. So I've refused to sign any documents for well over 2 years. And so now there's an established record on their record of no such record. So think about this stuff, people. This is one of the things I use to get over all my fear about this commercial system. And I just quit the commercial system. I no longer involve myself. I don't write checks. I don't sign anything. There are times that I use Federal Reserve notes only out of a doctrine of necessity. But other than that, you can drag me into court all you want. You're never going to get my signature. All you're going to get is a verbal statement from now on. And verbal statements of clarification, or verbal statements of my own information and clarification of information that's being put forth to me. Richie, that's UCC 3-402 section B subsection 1. I don't even bother with UCC 1-308 anymore. That right doesn't need to be reserved. Let me talk real quick about reservation of rights, and this is why I started using I retain and maintain rights. The reservation of rights. If you call up a fancy restaurant and you reserve a table, what are you doing? You're telling them you want them to hold the table for you for a future event. Okay, so when you're reserving your rights, are you reserving your rights for a future event, or are you maintaining them at the current time, the now time? I'm sorry, but there's no such record that I ever gave them up, period. There's implication on records that I gave it up, and that started out right when my mom signed that Social Security application and birth certificate, and then from there on, it was all cognitive dissonance through public education, indoctrination, propaganda. But again, I'm telling you, people, once you learn this information, you get rid of all that fear. You realize it's all bullshit. Excuse my language. And like I said, if I'm not liable for the person named on the instrument for anything that I sign in a commercial system, then neither are they. What's good for the goose is good for the gander. And that's why they're going through this and pushing everybody and violating everybody, because they don't realize this. They are not liable. This is the reason for the Clearfield Doctrine. Clearfield Doctrine says that once they act in a commercial capacity, they reduce their status to that of a mere private citizen. And as a mere private citizen, that is a personal capacity. Okay, they've dropped down from their private capacity into a personal capacity, and now they can be sued in their personal capacity. But you have to start signing documents in order to do that. Okay, comprehend this stuff. That the entire legal fiction or legal system is fiction. So the only way you can go after another man, again, it's Matthew 18 verses 15 through 20. Go to him first in private. If he doesn't make amends or bring clarification to what he's made an accusation of, then you go before your brothers and sisters in a ministerial fashion, not in a government fashion, in a ministerial fashion. If you read Romans 13, verse 4, you'll see they're supposed to minister, not govern. And it doesn't say that we're supposed to subject ourselves to government. It says we're supposed to subject ourselves to the ministerial properties of our fellow man. So think about this stuff, people, and realize no matter what you're signing, you're not actually liable, even though they imply that you're liable, and that's why they need your signature. Think about this stuff, people. Think about it hard. Get rid of all the fear. In the meantime, I wouldn't be doing this if it wasn't for you guys. Love you. God bless. Have a great day. Bye.